Last case on the docket today is Michael A. Rich versus Ralph A. UDICK.
May it please the Court. My name is Shannon Macklin Carlisle of the Carlisle Appellate Law Firm, and I represent the appellant, Michael Rich. Judge Torpy, may I please reserve 3 minutes for rebuttal?
Sure, I'll
Thank you.
adjust that accordingly. Yes, ma'am.
Your Honor, this appeal arises out of a defamation action filed by Mr. Rich against Ralph UDICK, who is a resident of the Harbor Hills community and in Lake County, where Mr. Rich is.
Let's take them one at a time. Let's take about the rape victim analogy. Would you do you think that is really hyperbole? Isn't it hyperbole?
I think that what it does is it clearly is stating that what UDICK is accusing Mr. Rich of doing is ripping off the homeowners. And that statement about don't blame the rape victim or blame the rapist is clearly a statement that...
Isn't that the same as saying don't shoot the messenger?
Yes, it is saying don't shoot the messenger, but what he's saying is, and look at the message I'm giving you about Mr. Rich, the developer of this homeowners association. And then what Mr. UDICK does is then backs up that claim by then making another statement that says this is not a criminal matter such as rape, not as bad as rape. And so that again is a further defamatory statement. The case law says that what you all need to do in looking at this complaint de novo is look at the totality of the circumstances and all of the statements in context. And so what's also important for you to do is to look at Exhibit B in the Second Amended Complaint, where Mr. UDICK states that Mr. Rich is self-dealing at an unprecedented level. And the definition of self-dealing is taking advantage of somebody that you have a position of trust in. Essentially what Mr. UDICK is doing is accusing Mr. Rich of being the Bernie Madoff of Harbor Hills. And the appellee makes a big point that this was not criminal in nature, but Mr. UDICK's statements, he's inconsistent there. On one hand, he says, oh yes, technically Mr. Rich can do this, but then on the other hand, he says, but it violates Florida law. So that's an inconsistent statement that can be read one of two ways, which shows that this is a jury issue as to whether this is a defamatory statement. The self-dealing at an unprecedented level is extremely defamatory per se, because you again have to look at the audience. These emails were sent out to 600 homeowners in Mr. Rich's development. Mr. Rich's job as the developer of this community is to try to convince people to move into this community. And so what are people who are prospective homeowners going to do? They're going to call members of the homeowners association and say, what's it like to live in Harbor Hills? How's the developer? How's the homeowners association? And you have these statements that were disseminated to 600 homes.
You bought a house and called up the homeowners association to see how things were going?
Excuse me?
You ever bought a house where you called the homeowners association?
it's rather ironic, but I'm building a house in Harbor Hills right now. And yes, I have called members of the homeowners community and said, what is it like to live in Harbor Hills? So yes, that is definitely something that occurs.
So if a homeowner thinks the developer is using an unfair assessment system, he has no right to say anything, because if he says it's unfair, that he can be sued for defamation?
No, he didn't say it was unfair. He said that Mr. Rich was raping these victims by ripping them off and self-dealing. Self-dealing is not saying I'm being unfair. And if you would turn to some of the other actions where the courts, including this court, has reversed for demonstrating that the cases did state a cause of action for defamation, the statements in those cases are much less egregious than the statements in this case. Let's see, the Wolfson versus Cook case, the defamatory statement was, we invited him out of the office. That was it. Referring to the plaintiff, because he was a stockbroker and he worked there. The court reversed a dismissal of a complaint for defamation because they stated that tended to injure his business or profession. It isn't stating that it absolutely 100% has to. It's saying that if the statements tend to injure somebody's professional business, this is Mr. Rich's profession.
A distinction between statements of fact and statements of opinion?
There have been a distinction, and I'd like to refer to the, Milkovich case. Milkovich case, which is a U.S. Supreme Court case, specifically says you can't couch your statements as opinion and have that be a resolution to absolve you of any sort of liability. What you have to do is you look at whether if there's a statement that could be opinion or fact based on undisclosed information. And in this case, Exhibit B, Mr. UDICK gives a bunch of figures, and then as a fact, he says, this is self-dealing on an unprecedented scale as a fact. And that fact can be proven false by Mr. Rich, that this is not self-dealing. And again, you go back to his two statements that, well, he technically can do this. That's what he's trying to argue as a defense as to why this isn't a defamatory statement. But that's inconsistent with his contradictory statement that says, but what he's doing is violating Florida law. So he's saying he's violating Florida law, he's self-dealing, he has a fiduciary responsibility to these members of the Homeowners Association, and this is a motion to dismiss a complaint. This is not summary judgment, this is not a jury trial, this is access to the doors of the courthouse. And so...
Would the statement simply, it violates Florida case law according to my research, be actionable?
Again, I remind you that you have to take all of the statements and the totality of the circumstances as a whole. And because, again, he's trying to say that because he's saying, according to my research, that is an absolute absolving of any sort of responsibility. Because
well, let's say he'd sent this letter, he hadn't put in the rape reference.
Which he did.
Sets forth what the assessment scheme is and just said it violates Florida case law according to my research. Would that be actionable?
Yes, because number one, it includes all those other things that are in there, which you need to look at the totality of the circumstances. Number two, he sets forth these alleged facts to support his position, and then says, as a fact, this man is self-dealing on an unprecedented scale, exclamation point. And those facts on page 207 of the record is in the Second Amendment complaint, which specifically alleges that those facts are inaccurate and can be proven false. And so that is the distinction when you have a statement that can be classified as an opinion. If you have two ways to look at it, and some things is relying on undisclosed facts, then that also brings the matter within defamation per se. And in this situation, what does Mr. UDICK do? He says, oh yeah, I have more information back at my house that I'm not telling you about now. So again, this is all information that shows that this Second Amended complaint stated a valid cause of action for defamation per se. Because again, it doesn't matter whether or not he was accusing Mr. Rich of criminal matter, because the statements and the inferences and everything taken as a whole, and considering his audience, which the case law requires that to be considered, these statements tended, not even absolutely, but tended to injure Mr. Rich in his business or profession, which his business is trying to get people to move to Harbor Hills, to join the country club, to build houses there. And so respectfully, Your Honors, we believe that the trial judge erred in dismissing the Second Amendment complaint because it states a valid cause of action for defamation. I want to point the court's attention to a case called Straub versus Scarpa that opposing counsel cited as support for this not being a defamatory situation. And this case is readily distinguishable because, number one, it's not even a defamation case. It's a false light privacy case, which is not even in existence in Florida anymore. The homeowner, she analogizes this case because she said, oh, well, it's a homeowners association, disgruntled, members. In that situation, a homeowner wrote to other homeowners and said, hey, let me use your proxy because I think I could have other people voted on to the board that would do a better job and not spend as much money. And the court found that that did not state a valid cause of action for false light privacy because the statement was not outrageous, highly offensive is what that standard was. Well, I submit to you all that if this was a defamation case and that homeowner had utilized the term rapist and self-dealing of an unprecedented scale, and he also, again, classified the homeowners as victims, classified Mr. UDICK classified what Mr. Rich allegedly did as an offense. So these are all information to show that this tended to injure Mr. Rich in his business. I don't see a lot of questions, so what I wanted to do is I really want to address the appellate attorney's fees situation. I'm honored to appear before this court. I've been doing so for 15 years on a regular basis. And before our firm files an appeal, we analyze the case and we determine whether or not there's a good faith basis to bring an appeal. And if there is no good faith basis and an appeal is untenable, we will not take that case. There are times...
Are you getting to a legal point that you want to make here?
Yes, absolutely.
Why don't you get to
Well,
the
that
legal-
sounds like a lot of, facts that are outside the record about
No, Your Honor, the opposing...
firm and what it does.
The opposing counsel has filed a 57105 attorney's fees action against us stating that we brought this case with no legal basis to do so. Mm-hmm. And so I feel compelled to address the court.
Isn't that a question of law, though?
Excuse me?
Isn't that a question of law?
It's a question as to whether a lawyer in their professional judgment believes that the facts and the law are support the appeal.
Well, so you're saying we should remand, if we decide that we're going to award 57105 fees, we should remand the case to the trial judge to listen to your testimony about what you just told us about, so that he can decide what he or she can decide.
No, Your Honor, I'm trying to convince you not to...
It just sounds like a lot of extra record facts that, we really shouldn't consider.
Okay. Well, what I'll say then is I urge you to look at Scott versus Bush. and this was cited in our brief and also included as an appendix. The law of defamation contains numerous illogical twists and refinements stemming from ecclesiastic law, as well as the common law. It's overlaid with statutory and constitutional requirements. It's confusing, unclear, illogical, and somewhat in conflict. Courts and judges frequently disagree with another as to whether an actionable defamation has been established as a matter of law. And so I'm making a legal argument that there is not a basis to award 57-105 attorney's fees
I understand your legal argument.
in this matter.
Okay, want to say some rebuttal time?
Thank you.
All right, yes, ma'am. All right, we'll hear from the appellee.
May it please the Court. Good morning. My name is Mary Meeks, and I represent the defendant appellee in this case, Ralph UDICK, who's here today. And obviously this is an appeal of the dismissal with prejudice of a defamation claim that the trial court correctly recognized was completely devoid of any arguable merit, and in fact represented a blatant attempt by the plaintiff developer in this case to punish, intimidate, and shut up a homeowner who was exercising his right to criticize the developer, who was also the head of the Homeowners Association. And counsel mentioned the Straub versus Scarpa case, which I readily agree is not a defamation case, but it is still relevant to this inquiry because it is eerily similar to this case. The facts are almost identical as far as
Aren't the elements different, though?
Absolutely, and I don't cite the case for the elements of defamation. In fact, again, as counsel mentioned, the false light claim no longer exists. It's even a lighter burden to establish a false light claim than a defamation claim. But the important point there that the court made was that in a residential community governed by a homeowners association, vigorous debate over community expenditures is a value to be encouraged, not a pathway to litigation. And to encourage litigation in a case such as this is to stifle discussion and place political power in the hands of those wealthy and aggressive enough to finance a lawsuit.
Do you think that the language your client used was appropriate?
Appropriate to what? I think the legal question is, was it defamatory?
The discussion and the debate of expenditures within the Homeowners Association.
Well, the question is, and right up front, Your Honor, you said let's talk about the two specific allegations here.
Well, I asked you whether you thought your clients, these emails are appropriate to this debate of the assessments of the Homeowners Association. Do you think that this is appropriate discourse?
Your Honor, I don't know that opinion is even relevant. The question is does it constitute defamation? I would admit that I find personal... I've asked you the question, Ms. Meeks, and I'd like you to give me an answer to it. I have admitted readily I would find personal offense to any use of rape as an analogy outside of a context of some actual physical assault on somebody. So in that sense, personally, I would find it inappropriate. The second comment in which he, in writing, actually used the quote, we are victims of a financial, quote, crime, and then clearly explains after that he is not intending to claim that it was actually a crime, but rather a civil and contractual matter. I think that certainly falls within the level of vigorous debate. And going back then to the rapist comment, and I think the questions from the court there were right on point. And let's be clear, he never said Mr. Rich is a rapist. Even the comment itself, it was not even directed at Mr. Rich. It was, as you pointed out, directed to himself. So he attaches a letter that he sends to the developer where he sets out in great detail his opinion about the prospective application. It had been passed, not implemented yet, so he was setting out his opinion about the prospective application of an amendment to the declarations, which clearly would change the method of assessing, of calculating the assessments for the homeowners, and gives his opinion about that. Now, he then attaches the cover email to that, and at the end of it, you can see from reading in context, he's preemptively apologizing to his neighbors and fellow homeowners. And I think the, don't shoot the messenger analogy is, and that perhaps he should have used that analogy and left it at that. But the analogy was directed at him. It wasn't even directed at Mr. Rich. He could have been complaining about anything and still use that same analogy to say to his neighbors, sorry to be bringing this up. I know it's not a fun topic. It could create some controversy, but don't blame the victim. Don't shoot the messenger. The fact that he used the rapist analogy maybe wasn't the best choice in the world, but even then I do think it does not cross any line that's prohibited by any legal definition, and certainly not defamation. And again, I think the court's questions correctly make the distinction between opinion and fact. Now, the statement that Mr. UDICK made about the rapist issue was clearly not a statement of fact. It wasn't even really a statement of opinion. It was an analogy, and an analogy completely unconnected to the underlying issue. I would like to believe that there is simply no credible argument whatsoever that you can turn that comment into a sustainable defamation action under the law. And I would also add, and this applies to both of the alleged defamatory statements. So if, and I'll get to the second.
I'm sorry, go ahead. I'm sorry. No, you go ahead. No, how about a statement by a former client of a lawyer that, her bills are tantamount to rape, meaning that she gouges on her bills. Would that be defamatory?
If a statement was made that could reasonably be interpreted to impute that particular allegation,
right? I mean, if a bill is tantamount to rape, it's a fair inference that it's just so out of bounds that it's criminal, right? I mean, isn't that defamatory?
I think, again, these are hard to assess a hypothetical. I think in a certain context, if the hypothetical you're giving me, it could reasonably be interpreted to impute a specific act of misconduct that would be inherently considered defamatory to someone in that profession, I would agree with you. But what I think is the fatal factual flaw in this case with regard to both of the allegations is, so if number one, if we assume, and I think that this is obvious, if we assume that neither of these statements can be reasonably interpreted to accuse Mr. Rich of any literal crime. He clearly is not accusing him of being a, quote, rapist. He clearly is not accusing him of any specific crime. He says he's not. So you take those issues off the table. He's clearly not accusing Mr. Rich of any specific crime. So the next question is, has he said something that can reasonably be interpreted to impute a specific act or specific conduct that rises to the level of defamation per se? And that is the great big donut hole in appellant's argument. To this day, they have not identified any specific act that they claim that these statements accuse Mr. Rich of. So if he's not being accused of being a rapist, and he's not being accused literally of committing a crime, then what is it? What is it that Mr. Rich says that he was accused of by Mr. UDICK? What specific act is he accused of?
How about self-dealing on an unprecedented scale?
And, Your Honor, that's a great question. Again, obviously, that statement in and of itself is a statement of opinion, perhaps hyperbole, based on the opinions Mr. UDICK has given about this new amended method of assessment. Again, and then we've cited a number of cases, and if I don't get to all of them, Your Honor, there's 5 or 6 of them that are great examples where statements have been made using terms that clearly could denote specific crimes: robbery, murder, cheating, stealing.
Well, isn't self-dealing? He's got his hand in the till. He's stealing from the people within the homeowners association. Isn't that at least a valid inference for purposes of surviving a motion to dismiss?
Not based on the totality of these statements. And again, the cases that are cited, there's ones very specific where there are statements made about somebody stealing and robbing, and I think even the specific example of having their hand in the till. What's important is, based on the totality of the communication, what is it exactly that he's being accused of? And in this case, there's only one logical answer to that. If you read Mr. UDICK's entire communication, if you even want to use the word accuse, what he is complaining of is that Mr. Rich, in his lawful position as a developer, lawfully used that position to pass an amendment to the homeowner's declarations to alter the method of assessment. He's done some research on the matter, and he quotes it. He's quoting from case law. And then he says, as Your Honor, as you pointed out, in my judgment, Amendment 2 is unreasonable and unenforceable. So the only specific misconduct, if you even want to use that word, that he's accusing Mr. Rich of, is using his position as a developer to change the assessments in a way that he legally is entitled to change them under the declarations, in a way that serves his interest in that he as a developer is paying less and the homeowners are paying more. There's nothing illegal about that. He's not accusing him of anything illegal or even unethical. He's simply saying it's unreasonable. He's saying this man has used his position to change the assessments in a way that serves his financial interest and makes us pay more.
Contrary to Florida law.
Contrary to his interpretation of Florida case law that says that when a developer lawfully exercises their right to create such an amendment, they cannot do so in such a way that changes the fundamental scheme of the development. And he believed, in his opinion, that the prospective effect, which had not taken place yet, and I actually don't think it still has, that the prospective effect of this amendment would, in his opinion, change the fundamental scheme of the development in contravention of the Florida case law that he cited. That's clearly an opinion, and one of the examples in our brief, the Stimbridge case, is very similar, because that one involved allegations of counsel, a party in a case actually filed a bar complaint accusing his opposing counsel of misquoting Florida case law. And he argued his case law to that effect, and the court found that that simply was an opinion, and it was clear that it was an opinion. And so I would just point out to the court, in the Palm Beach newspapers case, was clearly, that was the one where they actually used the fingers in the pot analogy and used terms like cheating and stealing. And in the specific context of that, the court said, as it did in that case, the Seropian case, the Greenbelt case, the Zork case, and the Stimbridge case, are all great examples where there's pretty extreme hyperbole and rhetoric used, but the court said clearly the speaker of those words was not accusing the plaintiff of literally committing those crimes, so that ends that inquiry. The next inquiry is, based on the totality of the communication, have they accused the person of a specific act of misconduct, first requirement, that rises to the level of defamation per se, second requirement. And in this case, I don't even know, again, what it is. Self-dealing is not a specific act of misconduct. It, again, applies, that's a conclusion, that's an opinion. What is the specific act here? The specific act is he passed an amendment that changed the method of assessment. Mr. UDICK didn't like it.
Whatever happens in this case, you're here, we're all here, your client is here having to presumably have expended attorney's fees, because the level of discourse, matches that of politicians of late, and I think that we would all do better to understand that civil tone, civil discourse, is an appropriate and preferred method of communication.
Your Honor, on a personal level, I would absolutely agree with that. But in this case, the question is whether the trial court correctly dismissed this complaint with prejudice. And I don't think there is much of a legal argument on that point. There is simply...
Did you get 57-105 fees below?
Your Honor, we've not had that hearing yet. We agreed...
Move for them.
We moved for it, and we agreed to hold it until the appeal was finished. And that's why we couched our motion on appeal. It seems to me the most appropriate resolution might be, assuming that the trial court's ruling is upheld, to simply award the appellate fees on the condition that that's what occurs.
Is that your sole basis for fees of 57,105?
Yes, it is, Your Honor.
I'm not going to vote for you on that.
Okay. I appreciate that, Your
I don't know
Honor.
what my colleagues are going to do.
I'm sorry?
I don't know what my colleagues are going to do.
Okay, I appreciate that, Your Honor.
Yes, ma'am.
Again, the primary point that I would make on the appeal is, the question is there any way that the court can reasonably interpret, these two pieces of paper authored by my client to justifiably allege a defamation per se, which is an extremely high level. One way to do that is to accuse someone of a crime. He clearly did not do that. The second fallback argument that counsel has made is this imputation of conduct incompatible with his lawful business. But still to this day, and so I'm throwing out hypotheticals. What could it possibly be? It's never been stated. On rebuttal, I don't know what counsel might finally say. What is the imputed conduct? It's never been said. And as far as the actual pleadings, the comment was made that in the pleadings they alleged that some of the factual, she says, but I think it's clear they were still opinions, but some of the underlying basis for Mr. UDICK's ultimate opinion were false. But they didn't allege what they are. And Florida law clearly requires that a defamation claim allege with particularity the alleged defamatory statements. So the only two that were alleged, and that could be alleged, frankly, were the rapist statement, which we've addressed, the financial crime statement, which we've addressed. The self-dealing was not actually alleged. That's only been argued now on appeal. But that one still, even by inference, still falls within the same category of opinion and hyperbole. And I would point out that the legal standard for opinion is not just where the facts are disclosed, but where they are otherwise available to the reader. And in this case, that's clearly the case. Mr. UDICK was one homeowner who made a communication to his fellow homeowners who were privy to all of the same information, and he even invited them to ask him questions about his opinion. And he said to them, I hope you'll agree. I hope you'll agree with what? My facts? No, my opinions. So there's no possible way, and no request has been made to further amend the complaint. And so simply on the face of it, there's just no way possible that these allegations can rise to the level of a defamation per se. I wanted to point out a couple of cases cited by counsel. The Wolfson case, again, I think Your Honor made the point, the allegation in that case essentially that a broker was fired, that's a factual statement, completely irrelevant to this case. And the few cases that the appellant did cite, I would point out that the key, again, the donut hole in the factual argument and the donut hole in the few cases that were cited as perhaps contrary to our argument, they all have the same problem. They all have statements that were made where the court said that statement clearly, even though it has the word rob or murder or steal in it, is not imputing that as a crime. In the few cases cited, there were additional facts where the court said that's not actionable as an accusation of crime, but there are other factual statements made that rise to the level of something that would be inherently incompatible with someone's lawful business. So without going through all of them, they all easily fall into those patterns. There's either some additional factual statement that's made that imputes conduct that rises to that level, or there's not. And that's clearly the basis of the holding in every one of these cases, whichever way they fall on. And the five that I kind of quickly outlined for the court are all cases where judgments were entered for the defendants as a matter of law. All cases where the court found that had language at least as extreme and hyperbolic as this case, that those did not rise to the level of defamation per se as a matter of law. So if there are no further questions from the court, again, I would just urge the court, if it has any questions at all, I think the best case to look at is the Florida Medical Center case, because it is an example of exactly what is missing in this case, and would ask the court to affirm the trial court's decision dismissing this complaint with prejudice.
All right, thank you, counsel. Okay. A little over 5 minutes, Ms. Gorman.
Thank you, appreciate it. I wanted to clarify a statement that was made by opposing counsel with regard, and I believe she said that the reason that the court dismissed this complaint was because it found that this was some sort of a harassment and, unconscionable retaliatory action, and there is no evidence whatsoever that the court made such a finding. And again,
well, nor would it be relevant anyway.
Exactly,
right? It either states a cause of action or it doesn't, right?
Exactly.
We know that.
The other point I want to make is that opposing counsel keeps hanging her hat on the fact that Mr. UDICK did not accuse Mr. Rich of a crime. And there is an exception where defamation per se is still actionable and states a valid cause of action if it doesn't rise to the level of accusing somebody of a crime, but if it tends to impute their ability to conduct their profession and their business. And this clearly does. And I want to point to this court's case called Hawk versus Rissman-Weisberg. This is a case where, again, innuendo, a law firm held a seminar and stated their opinions of all these different judges and what they like and don't like. Those were opinions by that law firm. And one of the members of that law firm stated to the seminar that a particular judge liked men in tight shorts. That was it. That was the defamatory statement. The court found that that was defamation per se because it inherently inferred that that judge, it impugned his ability to do his work. And self-dealing, given Mr. Rich's position as the developer and chairman of the board of directors of the Homeowners Association, clearly tends to impugn his ability to practice his profession. The opposing counsel says that she still has not heard what it is that is defamatory, or that Mr. Rich, or excuse me, that Mr.
She said what act?
Yes, what act?
And identify clearly what act it is that he's accused of.
Self-dealing is where a corporate officer takes advantage of his position in a transaction and acting for his own interests rather than for the interests of those to which he owes a duty, and may involve misappropriation and usurpation of corporate assets.
Was that the act that was identified in the complaint and argued below?
That was the act that was specifically stated on page 207 of the complaint, where Mr. Rich alleged that there were inaccuracies, factual inaccuracies in the communication, and that was one of the factual inaccuracies. This is proven to be able to be proven.
Did you argue that to the trial judge? Did your client argue that to the trial judge? Self-dealing was the accused act?
The trial judge argued that the defamation made up exhibit that was alleged in the complaint made up Exhibit A, Exhibit B, and Exhibit C, and attached those three documents to the complaint. Exhibit B of that complaint has that statement about self-dealing, and in the second amended complaint, the trial judge argued that there were misstatements in that area. And so when you take, like raping the land, raping the homeowners is ripping them off, cheating them. That's what that means. And to buttress that with the statement that it is that self-dealing at an unprecedented scale, with an exclamation point after it, is defamatory. And it is our position strongly that the court committed reversible error by dismissing the second amended complaint because it stated a valid cause of action. So we urge you to reverse and remand for further proceedings.
Okay, thank you for a well-argued case. A safe trip